Good day, guys. We will now discuss Title 9 of the Revised Penal Code, Crimes Against Personal Security, Liberty and Security. Okay, Articles 267 to 292. First crime under this title is Article 267, Kidnapping and Serious Illegal Detention. So you really, diba, it's familiar to you. This crime is familiar to you because sa mga drama, sa mga action movies, awaning kidnapping and serious illegal detention. Muna siyang low plot, kumbaga sa mga crime movies. Okay, when is this committed? It is committed when private individual kidnaps or detains another, or in any other manner to deprive him of his liberty when such detention is illegal, and it is committed by any of the following circumstances. If kidnapping or detention should have lasted for more than 3 days. Okay, if it is committed simulating a public authority, ibig sabihin nag-ilog-ilog sila sa public authority in order to kidnap a person, like madress sila or masuksok sila by isang police officers or law enforcers para mag-upod sa ilang kidnap nila. Or if threats to kill had been made upon a person kidnapped or any serious physical injuries are inflicted upon the same, like bugbog niya before nila para mag-upod sa ila, or di man ginpahog siya nga patyon siya. Or if the person kidnapped or detained is a minor, female, or a public officer. Okay? Any of the circumstances present, then we have serious illegal detention. So tandaan nyo guys ha, minor, female, public officer. If minor, female, or public officer ang kidnap, the crime is serious illegal detention. So who is the offender in Article 267? He must be a private individual, because if he is a public officer who is vested by law to make an arrest and he detains the person, gin-discuss na nito guys, ang crime maging commit niya is Article 124 or arbitrary detention. So, ang makakommit sa illegal detention is a private individual. If a public officer ang nag-commit sang crime nga vested vested by law to make an arrest or detain a person, like police officers, diba? Barangay tanod or kapitan, for instance. It will make the crime as arbitrary detention. Okay, can a public officer commit kidnapping and serious illegal detention? Yes, if the said public officer has not been vested with the authority to effect an arrest. Dapat guys, vested lang sang authority to make an arrest for it to be under Article 124, di ba? Ang pwede bala ka pang aresto, hindi man tanan nga public officer, pwede ka pang aresto, di ba? Like for example, dira kaya gaubra sa LGU o kung sa isa ka public nga agency, diba, hindi ka man niya authorized to make an arrest. So, if a person who is a public officer acting in his private capacity commits the crime of kidnapping and serious illegal detention, ang crime maging commit niya is serious illegal detention and not arbitrary detention. Okay? The second element requires that the offender kidnaps or detains another or in any other manner deprives him of his liberty. So, bali, i-deprive ka sang imo nga liberty, hindi ka halin. When is there detention? Paano ko mahambal nga may detention? There is detention if the offender restrains a person or restrain a person or the liberty of another person. So, ginakwaan siya sang freedom. Kumbaga, wala siya liberty. He must be detained, incarcerated. There must be showing that the person, there must be showing that there is a restraint on this person or his liberty. Otherwise, there is no restraint on the person or liberty on the part of the offended party. It could be any other crime but not kidnapping and serious illegal detention. So dapat may restraint, guys. Restraint is very important for it to be kidnapping and serious illegal detention. The law requires that the kidnapping and detention must be illegal therefore, there must be no reasonable ground. So dapat illegal ang pag-detain sa imo. So kung hindi ka pagpahalino ni mama mo sa balay nyo, wala ka liberty. So is that kidnapping? Is that serious illegal detention? Probably your parents have reasons or reasonable grounds to ask you to stay inside the house. Diba? So circumstances which will make the crime serious. Okay, the kidnapping or detention should have lasted for more than 3 days. Okay, for the crime to be serious, dapat 3 days. Or if committed simulating public authority. For example, by pretending to be police officers or NBI agents. Okay, if any serious physical injuries are inflicted upon the person kidnapped or detained or threatens to kill him. Okay, or threats to kill him are made. And if the person kidnapped or detained is a minor, unless the offender is his parent. So sorry guys, if you are a minor, pwede ka gina ma-detain sa iyong mga parents. A female or public officer. The presence of any of these circumstances will meet the crime of serious illegal detention, and absence of any of the circumstance will make the crime slight illegal detention under Article 268. Okay? The first man na ibalagay sa murder and homicide. Diba? There must be circumstances. If there are circumstances that qualifies it to murder, then it is murder. Absent those circumstances, it will make it homicide. So in this case, you have to remember the four. Okay? Kung wala ang 4, slight illegal detention. If present ang 4, then that is serious illegal detention. So note that the penalty is preclusion perpetua to death. Okay? Circumstances that will qualify the penalty. If the purpose of the kidnapping is to extort ransom. Extort ransom from the victim or from any other person. So, the crime is qualified to kidnapping and serious illegal detention for ransom. What is ransom? Anong ransom? Ransom is the money, the price, or any other consideration given or demanded for the redemption of liberty of a person who has been detained or incarcerated. People versus Mamantak, my case, guys. Okay. Well, the mother and the daughter were ni guys. Okay. While the mother and the daughter were in a food chain in Tondo, the mother lost the said child. She had been looking for the child for a year. So a year and 6 months thereafter, the mother received a call from a woman who sounded to be a masculine man from Lanao del Norte. According to the said woman, she has the child with her, and the woman was demanding 30,000 pesos in exchange for the child. The woman, Mamantak and company, asked the mother to go. The said woman, Mamantak and company, asked the mother to go to a certain restaurant. Okay, the mother went to the said restaurant. However, the mother already informed the authorities. So upon the exchange of the child and the demand, Momantak and company were arrested by the said authorities. The crime charge was kidnapping and serious illegal detention for ransom. Why? Why serious, guys? The the victim was a minor first, tapos more than 3 days ang detention sa iya. In fact, more than a year and a half, di ba? So, we don't know what the gender of the child is. So, female, I think. Daughter, yes, female. So, it makes it serious illegal detention. Daughter nakalagay, guys eh. Okay, so RTC ruled that it is only kidnapping and serious illegal detention for ransom, but not for ransom because according to the trial court, the amount given is measly a sum to be considered as ransom. So, taman kuno kagamay para ma-consider nga ransom according to the RTC. It is only in payment for the board and lodging of the child during the time that she was in captivity of the said woman. Okay? Sa SC ruled that the crime committed is kidnapping and serious illegal detention for ransom, even if it is only 5 centavos. If it was given in exchange for the liberty of the person who has been detained by whose liberty has been restricted, it is already considered as ransom. So, ransom can be big or small. So there is no such thing as a small amount insofar as ransom is concerned. So here, biskan gamay lang ginanggit pa ngayon sang kidnappers, ano siya gyapon, qualified siya gyapon into kidnapping and serious illegal detention for ransom. So let's say A may utang kay B. B was asking payment from A. A, however, said that he has no money until B got fed up. So what B did was he kidnapped and detained the minor child of A. He then called A, telling the same, "I will only release your child the moment you will give your utang in the amount of 1,000,000 pesos." So the crime committed is kidnapping and serious illegal detention for ransom. Yes, it is. It is already kidnapping and serious illegal detention for ransom, even if the amount being asked by the kidnapper is the indebtedness of the father of the said child. Biskan utang to, guys, okay? Any amount demanded in exchange for liberty of the person detained, that is already considered as ransom. So, ito guys, gani, qualified siya ko. Kidnapping and serious illegal detention with ransom. If you do it, nangayo ka sa ransom. Ano naman niya, when the victim is killed or dies as a consequence of the kidnapping or detention, like for example, nagutman, napatay, nagtakas ang tao, na ipit, napatay, it is as a consequence of a kidnapping or detention. So, kidnapping and serious illegal detention with homicide. So, this is a special complex crime. Therefore, since it is a special complex crime, regardless of the number of the victims killed, it is still kidnapping and serious illegal detention with homicide. People versus Laranaga, I think. Okay, there are 2 kidnapped victims here, 2 sisters. Probably this is familiar to you. The Paco Laranaga case. Doon nagsikat siya sa Facebook. Okay. Because a movie was made out of this scenario or this kidnapping incident. Okay, there were 2 kidnapped victims, 2 sisters, both killed and raped, yet the SC held that the crime committed was kidnapping and serious illegal detention with homicide and rape, despite the fact that there were 2 victims who were killed and raped, because regardless of the numbers of the victims killed, since it is a special complex crime in the eyes of the law, there is only one crime committed. So it is only kidnapping and serious illegal detention with homicide. Note, however, that it is required that the victim himself is the one who has been killed. If another person, it will result to a separate and distinct crime, because the law is particular that the person detained or kidnapped must be the one who is killed or died as a consequence thereof. So kung hindi victim ang napatay langga, mga langga, guys, or kung hindi victim ang napatay, like for example, i-rescuer nga family member niya o na sa like for example, sa pag-kidnap sa iya, may ginpatay para makidnap siya, then ano siya, it is a separate and distinct crime. He can be prosecuted for killing the other victim, and then kidnapping sa this victim who was detained. Okay. What if A kidnapped the child of B, who is his enemy? The said child is 10 years old and he was placed in a hideout. The child tried to escape, but A saw him, so A fired a shot towards the child, which resulted to the death of the child. What crime is committed? The crime committed is kidnapping with serious illegal detention with homicide. Okay. Guys, kagina ha? Kidnap ni A ang bata ni B. Ang bata, 10 years old, kaginbutang sa hideout. Pero nagtaka si A, ginbaril si A. Okay, napatay si A. Here, what if in the same problem, the father learned about the sad kidnapping, so the father informed the NBI agents. The NBI agents were able to track down the place where the child was being hidden, so the NBI agents, together with the sad father, went to the hideout. There was an exchange of gunfires between the kidnapper and NBI agents. Well, there was an exchange of gunfires. The father saw his child, so the father rushed towards the son, carried the son, and they were able to leave the said hideout. While they were leaving, a kidnapper saw them, and the kidnapper shot the father. Okay, so what crime or crimes is committed? So if in so far as the minor is concerned, the crime of kidnapping and serious illegal detention, di ba? Kidnap yagin man. So even though it did not last 3 days, but the offended party was a minor, so it is already kidnapping and serious illegal detention. Insofar as the father, ginbaril lang siya, di ba? Pero we assume that he was killed. Okay, insofar as the father who has been killed, he is not a victim of serious illegal detention because he was not detained. It will constitute a separate and distinct crime of homicide. Okay, so there are two crimes gonna commit sa kidnapper. Kidnapping and serious illegal detention and homicide. Okay, therefore, there are two crimes committed by the said kidnapper, kidnapping and serious legal detention insofar as the child is concerned, and homicide insofar as the father who has been killed is concerned. Okay? So when the victim is raped, and gani guys, ang isa kagina, when for ransom. Tapos when killed. And now when the victim is raped. So kidnapping and serious illegal detention with rape. So it is necessary that the victim is the one who has been raped. Okay? Base ang yaya sa victim ang rape or someone else, diba? Again, this is a complex crime. So regardless of the many times the victim has been raped, this is actually sad, guys. There's no multiple rape kung kidnap siya. But then again, kung rape lang siya yung rape without kidnapping, there can be multiple rape. Diba? You learned man sa aton previous discussions that every act is one count of rape. So if a person raped you several times, he can be prosecuted for all several acts of rape, okay? But then again, if he was kidnapped or she was kidnapped, there is only a special complex crime of kidnapping and serious illegal detention with rape. There is no kidnapping and serious illegal detention with multiple rape. Okay. That's the fourth one. When the victim is subjected to torture or any dehumanizing acts. So the presence of these circumstances will bring about the imposition of maximum penalty of death. So if you're victim, hindi ka na kontento, ano mo pa, yung torture mo pa, I have to correct this one, guys, because there is no such thing. The penalty of death is not yet reimposed, kumbaga. Okay, so the maximum penalty is reclusion perpetua. Okay, so there is no penalty of death yet. Okay, the presence of these circumstances will bring about the imposition of maximum penalty. But the maximum penalty as of date is not death, but reclusion perpetua. You remember that, okay? Base di ba, you can hear gurus man sa news nga may mga moves to bring back death penalty, di ba? Because it was suspended. It was suspended by Congress at the time ata ni Gloria because ang purpose ng pag-suspended to is to for human rights purposes. To give chance, kumbaga, for reformation of criminals, of those who were sentenced for a while, ha? Okay, here, a 6-year-old child is playing at the playground about 5 o'clock in the afternoon while his mother is hanging clothes. So a man, X, gave the child a candy and the child was so happy. So later, a man again approached the child and gave the child money. And then the same man invited the child to go with him. So since the child was so happy because of the man was so good to her, the child went with the man. So at 6 o'clock, the mother came looking for the child, but the child was no longer in the playground. So meanwhile, a man brought the child to his place. That evening, the mother kept on looking for the child. However, they could not locate the child. In the house of the man, the child was molested and raped twice. The following morning, when the mother opened the door of the house, she saw her child at the door with torn clothes and blood. So the man was charged with serious illegal detention with rape. Is the charge correct? Okay? Is there? The charge is wrong because the obvious intention of the man is to rape the child and not to detain the child. Therefore, as he said, the crime committed would be 2 counts of statutory rape and not only single indivisible offense of kidnapping and serious illegal detention with rape, but 2 counts of statutory rape because the said child is under 12 years old. Guys, remember statutory rape, and she was raped and molested twice. Okay? Therefore, unless and until there was an intent to detain on the part of the offender, it could be another crime, but not kidnapping and serious illegal detention. So the intention is the first that you will have to look at para mag-charge ng crime. Okay? The intention, is it to detain? If it is to detain, then it is kidnapping. Then, after na lang yan ay niya, yan na panumduman niya nga, ayari maning bata, i-rape ko ba? Di ba? But if the kitaon, gidya nga, Manyak ito yung guy kag ang iya gid yung main purpose is manyakan ang child. The crime committed is rape, di ba? Rape kung more than 12 years old. But if the child is under 12 years of age, that's statutory rape. Okay? Okay. A saw his enemy walking. He abducted his enemy and placed him inside a van. Ang puting van. The following morning, the said enemy was found in a vacant lot with 10 gunshot wounds. What crime is committed? So the crime committed is murder. Murder because obviously there was no intent to detain the offended party. The intent was to kill him. Therefore, the crime committed is murder and not kidnapping and serious illegal detention with homicide or murder as the case may be. Okay? In order for kidnapping and serious illegal detention to amount to rape, murder with homicide, with physical injuries, it is necessary that the intent is to detain, and in the course of such detention, the victim dies, raped, or subjected to torture or any other dehumanizing acts. So again, as mentioned earlier, the absence of any of the circumstances which will make illegal detention serious. Itong apat to bala guys, nanaan nyo to ha. The crime committed is only slight illegal detention under Article 268. Okay, slight illegal detention, makidnap and man-detain of another, absent any of the circumstances under Article 268, slight illegal detention. Okay. Storytelling naman. What if A, envious siya sa iyang neighbor? Taman siya kamahisaon. Okay? To teach the neighbor a lesson, he kidnapped and detained the said neighbor and placed the said neighbor in a secluded place in a vacant area one morning. So, however, later on, guilty man siya, na-feel sorry man siya para sa iyang neighbor. So, buyan niya man ang iyang neighbor that night. So what is the effect of that in the criminal liability of the offender A? Okay, so under Article 268, slight illegal detention. So if the offended party has been released, such release will be considered as a privileged mitigating circumstance because from the penalty of reclusion temporal, the penalty would be lowered by 1 degree, and that is prison mayor. So manaog siya. So hindi na siya mag-serious illegal detention, but maging prison. Ano lang siya? Slight illegal detention lang siya. Slight illegal detention where the penalty is lowered by 1 degree. It is considered as a privileged mitigating circumstance. Note, however, that this voluntary release of the victim may only be considered as a privileged mitigating circumstance if following requisites must concur. So it is necessary na gid-release mo siya within 3 days from the commencement of the said kidnapping. It must have been made without the offender having attained or accomplished his purpose, okay? It must have been made before the institution of the criminal proceedings against the said offender. So basi kay, di ba, before sa institution, kay basi ang main purpose mo giman niya tuod, pa nga gipalaya mo na siya, kay nahadlo ka na, kay kasuhan ka na. So, it must be before the institution of criminal proceedings against the offender. If all of these three are present, then such voluntary release of the offender will mitigate the liability of the said offender. So, mapanabuo ang kaso sa iya. What if the person kidnapped by A is a public officer? Diba guys? Diba? Serious to kung public officer, kung minor, kung female, diba? So what if the person kidnapped by A is a public officer? He is mad that the said public officer, he's mad with the said public officer, so he kidnapped the same and detained him in the morning. So in the evening, he immediately released the public officer because he told himself that perhaps the NBI would look after him. So he immediately released the public officer. Will such release mitigate his criminal liability? No, the fact that the person kidnapped is a public officer. The crime would be immediately kidnapping and serious legal detention under 267, diba? And if the crime is committed under 267, no amount of voluntary release will mitigate the criminal liability of the offender. So if the victim is a minor, female, or a public officer, automatically it will become kidnapping and serious illegal detention, and no amount of voluntary release will mitigate the liability. Okay, Article 269. Haba, nakita daw pa natin na-discuss. Okay. Article 269, unlawful arrest. Unlawful arrest is committed by any person who shall arrest or detain another without authority, by law, or without reasonable ground. Therefore, and his main purpose is to deliver him to proper authorities. So the purpose is to deliver him to proper authorities. A was walking when he was suddenly arrested by B, a police officer. The police officer said that a case has to be filed against him. The arrest was made without a warrant of arrest, and A was not caught committing a crime in flagrante delicto. No, so he was not caught in the act of committing a crime. He is also not an escapee. Okay? But he was incarcerated. Inkulong siya yapon. Thereafter, the case has been filed against him. However, there was no complainant. The fiscal dismissed the case for lack of probable cause. What crime is committed by the public officer? So the crime committed by the public officer is unlawful arrest. Okay? What about the fact that he was being detained arbitrarily? So, it is already absorbed, kumbaga guys, sa hindi ka arbitrary detention. It has already been absorbed because the intention of the said police is to file a case against him. So that is to deliver him to proper judicial authorities. So therefore, the arbitrary detention is merely incidental to the said act of unlawful arrest. So the crime that he committed is unlawful arrest. Na-absorb, kumbaga. Kidnapping and failure to return a minor. Kidnapping and failure to return a minor is committed by any person who had been entrusted with the custody of the minor who shall deliberately fail to restore the said minor to his parents or guardian. So, who is the offender? So the offender is a person entrusted with the custody of the minor. So like for example, yaya, di ba? Min-entrust mo custody. Or like for example, father man sa bata, pero bulaga na yun sa nanay. Tapos ang custody of the child because he or she, the child is less than 7 years old, the custody is with the mother. So, ano na siya? Intakas, like for example, sa tatay. Okay? When will the crime arise? A crime will arise if the offender shall deliberately fail to restore the said minor to his parents or guardian. Kung nalipatan lang, isa kadlaw nalipatan tapos or like for example, may emergency nga wala may madulong sang bata, or like for example, nagabihan na or wala sa lakyan, di ba? So it is forgivable. But if the failure to return the minor is deliberate. Okay? So, ginhuod nga hindi pagpabalik po ng bata sa iyang parents or guardian, then the crime of failure to return a minor, kidnapping and failure to return a minor is committed. What if A and B has a child and they entrusted the child to X? as they will be going for a vacation for a week. Wow, sana all. They told X to deliver the child to them after 7 days. So, a week after, the husband and wife arrived, but X failed to deliver the said child. The reason of X was that he was so busy with his work that he forgot that it was already the 7th day from the time that he has been entrusted with the child. So, he be held liable under Article 270? No, because he did not deliberately fail to restore the said minor to his parents or guardians. The law requires deliberate failure. So here, he only failed because of negligence and just because he was so busy. Kaya mo niya, nagbakasyon-bakasyon lang kamo niya, si ex yan, inubra, wala untat yung obra. Diba? Tapos si Failan, kapag kidnapping, ikaw na gani nagatipan sa bata. Bow! Okay? Inducing a minor to abandon his home. Okay? It is committed by any person who induces a minor to leave the home of his parents, guardians, or persons entrusted with the custody of the said minor. The crime will arise even if the child hasn't left the house of the parents or guardian. Mere inducement or intent to cause damage will suffice. So A and B, husband and wife's marriage has been declared a nullity by the court, and the custody of their 5-year-old child has been given definitely to the mother because less than 5 years old siya, guys. So, kung less than 7 years old ka, the custody, if wala man niya, like for example, hindi man immoral ang mother, hindi man hindi man maka-endanger bala kumbaga ang mother sa iya nga bata, the custody always is given sa mother. Most of the time, gid kung wala man ang rason nga i-deprive ang mother sa custody sa child, kinahatag ang custody sa child na less than 7 years old sa mother. So here, the child is 5 years old. So the custody is with the mother. So however, the father has been given visiting rights, di ba? May visitation rights. One Sunday, the father visited the 5-year-old son and the son was brought out by the father. Nag-shopping kumbaga sila or nag-ano sila. Usually, whenever the father takes his son out, he will return the child by nighttime. So one day lang, alagaw. However, this time the father did not bring back the child to the house of the mother, and so the mother demanded the return of her son, but the father still failed to return their child. Therefore, the mother filed a case of kidnapping and failure to return a minor under Article 270 against the father. So will the case prosper? Yes, the case will prosper. Under Article 271, it is provided that Article 270 and 271 can also be committed not only by strangers but also by the father or the mother. Okay? The only difference is that Article 270, if the offender is any other person, the penalty is reclusion perpetua. But if the offender is the father or the mother, note that the penalty is so low. Only arresto mayor or fine are not more than 300 or both fine and penalty depending upon the discretion of the court. Therefore, even if the father or mother can be held liable under Articles 270 and 271, the only difference is their respective penalties. So, mababa. Article 272, slavery. Slavery, elements of slavery. The offender purchases, sells, kidnaps, or detains a human being. Okay, the purpose of the offender is to enslave such human being. Actually, guys, do trafficking. Trafficking siya. It is committed by any person who shall sell, buy, kidnap, or detain a person for purpose of enslaving the said person. The purpose is to engage in immoral traffic. Then the penalty will be qualified. Exploitation of child labor. Offender retains a minor in his service and against the will of the minor. Diba? Ginapobra ka nga bata ka pa lang. It is under the pretext of reimbursing himself of the debt incurred by an ascendant, guardian, or person entrusted with the custody of such minor. Pambayad utang, kumbaga. Okay? So that is a crime. Diba? If you exploit a minor. If you make a minor reimburse, kumbaga, or pambayad sa utang. Tapos dalo mo na siya to kay pambayad sa utang. That is exploitation of child labor. Pero guys, it is committed by any person who shall detain a child in his service against the will of the child. Dapat it is against the will of the child. Under the pretext of reimbursing a debt incurred by the parents, ascendants, guardian, or any other person entrusted with the custody of the said child. Pero if it's your parents who is asking you to help household chores, that's not exploitation of child labor, okay? So, basi bala, patigangon ka mo ni nanay mo, tapos umalon mo, exploitation of child labor na. Well, anyway, basi wala naman sa inyo minor, basi tanan ka mo above 18 na. So, huwag kayong tuso. You help your parents as much as possible because kabudlay magpangita sa kwarta para ipakaon sa aton, di ba? So we help them as much as possible. Article 274, services rendered under compulsion in payment of debt. So, hindi guys sa isa, child labor because the victim is a child. Here, services rendered under compulsion in payment of debt. So, offender compels the debtor to work for him either as a household servant or farm laborer. So, it is against of the debtor's will. Pero guys, kung mag-agree man lang siya yung muna yung pambayad, then there is no crime committed. Pero kung ginpilit gid siya nga against your will, gin-threaten siya, ginano siya, then amo na ka makommit ng crime. Okay? So, you have to distinguish. The purpose is to require and enforce the payment of a debt. So it is committed by a creditor shall compel the debtor to work for him as a household servant or farm laborer against his will in order to require or enforce the payment of a debt. Abandonment of persons in danger of abandonment of one's victim. Okay? Ano din parusahan, kumbaga. What is the acts nga gina-punish dire under this article? So, failing to render assistance to any person whom offender found in an inhabited place, wounded or in danger of dying, when he can render such assistance without detriment to himself, unless such omission shall constitute more serious offense. Okay. Abandonment sang person nga ara sa danger. Okay? Failing to render help or assistance to another whom the offender has accidentally wounded or injured. Guys, kung mga example, mga hit and run bala, diba? Bukod sa crime maging commit nila nga reckless imprudence, they also abandon their victims. Okay? Kung man siyang accident lang siya without a criminal offense, kung accident lang siya, then you have to help your victim. Okay? If you don't help your victim or render help or assistance to the person na accidentally wound mo, then your crime is abandoning your victim. Okay? Failing to deliver a child under 7 years of age whom the offender was found abandoned to the authorities or to his family, or failing to take him, to the safe place. So, may makita ka mo nga under 7 years of age nga bata nga nawawala, you should deliver him or her to the authorities. Or like kung hindi mo kilala, makutumo siya kung sino yung pangalan. Kung hindi mo kilala, deliver mo siya sa police station. Okay, you help guys, help. Because the failure to do something, this is, diba, the failure to do something, this is crime by omission. Failure to do something is already a crime. Okay? Si A, nakita niya si B sa Luneta Park. Si B, he was wounded and was bitten by a dog, and he was crying for help. However, A, instead of helping B, left. Okay? Is A liable under Article 275? What do you think? What do you think? Okay? No, because the Park Luneta is a public place. So it's not uninhabited. But must be uninhabited. Okay? People come and go. So kung si A lang, A is not liable under Article 275 despite the fact that B is wounded and dying. Okay? Subo, no? Kumbaga nila, di ba? Ang place is mas damot tao. Mas gamay ang possibility nga may mabulig sila. Kaya naghulata na yung mga tao, mabulig mo. Gawin mo ng a theory. But then again, because mabuot kita we will help a person na we see nga in need of help. Okay? An inhabited place is one wherein there's a remote possibility for the victim to receive help. So, ikaw na lang gid makabulig siya, tapos way mo pag-imbuligan. So, you're liable of the crime, abandoning of a person in danger. Okay? So, what if in the same problem, A found B in a forest? So, naghunting si B sa forest. Nakita niya si A naghunting sa forest. Nakita niya si B. Tapos, nahulugan din si B sang troso sa neck. He could not move. So, he was begging for A's help. So, A, however, left. Okay? B was rescued. Can he file a case of violation of Article 275 against A? Yes, because B was found by A in an uninhabited place, and he was wounded and in danger of dying because of the big trunk of tree on his neck. There is no detriment on the part of A to render assistance, but he failed to render assistance because I don't know, anong rason nga wala siya ka-render assistance. Tamad lang siya na selfish siya di ba? So therefore, A may be held liable for violation of Article 275. But what if when A found B and he was bitten by a snake and the snake was still there? Okay, miyara na sang danger sa iya. So, hindi ko yan magbuli. Kaya pag mga snake, di ba? Nandulo ko sa snake mo. So, can A be held liable under Article 275? No, because helping B will be detrimental on his part. Di ba? Iko ako to yung karon kadton siya mabulig sa akon. Mata siya. Okay? So, you should distinguish, guys. Wala man lang detriment sa iyang kasi hindi siya magbulig, selfish lang din siya. Pero kung may danger man sa mga life, ang magani nila, first rule, di ba? Nga, like for example, may mga danger, save yourself first. First rule sa mga, sa mga survivor, di ba? Mga Traversianes. Okay? What if A was driving his vehicle when his car tripped on a stone, so the stone flew and hit the eye of a bystander. The left eye bled. Is A liable? No, because it is purely accidental. It is an exempting circumstance. Diba? Crime Law 1. Oh my God. It is an exempting circumstance if It's an accident, okay? He was performing an act with due care and the accident happened without the fault and negligence on his part. Aksidente lang ito yung may stone dito ya paano mo to yung makita kay pagkagamay-gamay man lang to naga-focus ka sa driving, di ba? Okay. What if the left eye of the bystander, what if when the left eye of the bystander bled, A saw him and he knows that the bystander is his victim. However, instead of bringing the bystander to the hospital, he increased his speed and left. Nagsarurot siya, lahat siya. Is A criminally liable this time? For the first act, he is not liable because it is purely an accident. But when he failed to render help or assistance to his own victim, it becomes a crime. Okay? It is a crime under Article 275. And what crime is that? Abandoning your victim. Okay? Abandoning a minor. The offender has the custody of the child. Child is under 7 years of age. He abandons such child. He has no intent to kill the child when the latter is abandoned. Wala man siya intensyon nga pat yun. Hindi niya lang niya, like for example, hindi niya lang mabuhi. Diba? Abandoning a minor is committed by any person who has been entrusted with the custody of the child under 7 years of age and he abandons the said child permanently, deliberately, and consciously pero hindi niya man intent to kill. Hindi siya yung hindi siya yung wicked ang witch sa Snow White nga ipapatay niya si Snow White sa forest, di ba? Inabandon lang siya ang huntsman. Inabandon lang yung child sa forest. Wala siya intent to kill. Kinabuhi mo niya si Snow White, magpupulipot siya sa mga dwarves. Tsaka ang story, yung inambal ko, basta mo na siya. Okay, so the penalty will be qualified if death resulted from the said abandonment. Okay, but when the safety of the child has been, when the safety of the child has been placed in danger. So kung mag-abandon ka sang child mo, or magbahang-abandon ka sang bata, dira mo siya i-abandon sa place na doon may damo tao, makabulig sa iya, o kung pangay siya bulig, diba? Or man siya, nabuhi man siya, kumbaga. Okay? Because if you abandon the child, or you abandon the child sa lugar nga, he will be or he or she is in danger. Like for example, sa balayan sa mga snakes. O, balik na natin sa snakes kay. Diba? So, sa forest, nadamo snakes. Well-known, nadamo snakes. So, the safety of the child has been placed in danger. May lang kung may mga dwarves na magkuwag sa iya before siya makagat sa snake. Diba? The penalty will be qualified if death is resulted also. A woman, an OFW worker who left his newborn child inside the garbage bin of an airplane. Later, she was been arrested. What crime was committed by the said mother? Abandoning a minor under 276. Okay, kasubo. Mother is in custody of the child and she deliberately or consciously abandoned her child without intent to kill. Obviously, there is no intent to kill because she could have killed the said child. Diba? Instead, ginbutang niya sa garbage can, sa restrooms, ang aircraft. Okay? So, there was no intent to kill. Ang crime na nakomit niya lang is abandoning a minor. Abandonment of a minor by a person entrusted with his custody in defense of parents. So, pagpapabaya. Abandoning a child by a person trusted with his custody. This committed by any person who have been entrusted with the living or education to said minor shall deliver the minor to a public institution or persons without the consent of the person who entrusted such minor to care of the offender or in his absence without the consent of the proper authorities. In defense of parents, it is committed by any parent who neglects any of his children by not giving them education with their station in life requires and financial capability permits. Okay? Pero note dire ha, nga when which their station in life requires. Okay? Kinanglan nila sa status nila, kumbaga kag may ara sila sang financial capability to do so. Pero hindi kapag pa-eskwelahon sang kinikanan mo. Okay, base mas mag-alam ka pa sa ila kag sabton mo sila. So, no. In difference of parents, if the parent neglects to, if your parents can afford to give you the education with their income, kumbaga, or financial capability, then they should give you education. Because if not, they will be liable sa crime and indifference of parents. But if your parents cannot afford to give you education, isang kahig, isang tuka lang, although may mga public schools man actually that can cater to you, then tinguha ka lang ano daw anhon na diba? Because not everyone were born with a silver spoon. So if you are a child whose parents cannot support you sa education mo, then if you strive enough, diba? May mga scholarships man, may mga educational grants man na pwede yan sa inyo. You can be scholars, diba? Kasi city scholar. Charot. Exploitation of a child. Okay? Exploitation of a child. How is this different from the other one? Labor. Okay? Labor itong isa. Exploitation of a child. Causing any boy or girl under 16 to engage in any dangerous feat of balancing, physical strength, or contortion. Okay? The offender being any person. So, employing children under 16 years of age who are not children of or descendants of the offender in exhibitions, acrobats, gymnast, rope walker, diver, wild animal tamer, or the offender being an acrobat, etc., circus manager, or person engaged in any of the said callings. So that's dangerous for children. So don't gitahambagan. Di ba may mga palagwaon sa TV nga muna, don't do this at home because it's dangerous. So if a child does this, dapat may mga exceptions. Di ba may mga permits. Dapat parents, descendants mo, ascendants mo. Okay. Implying any descendant under 12 years of age in dangerous exhibitions enumerated in the next preceding paragraph. The offender being engaged in any of the said callings. Okay. Delivering a child under 16 years of age gratuitously to any person if any of the callings enumerated in paragraph 2 or to any habitual vagrant or beggar. The offender being an ascendant guardian, teacher, or a person entrusted in any capacity with the care of the child. So including any child under 16 years of age to abandon the home of its ascendants, guardians, curators, or teachers to follow any person entrusted in the callings mentioned in paragraph 2 or to accompany the habitual vagrant or beggar, the offender being any person. So these acts are considered as exploitation of minors because the acts endanger the life and safety of the growth and development also of the minors. So usually this involves circus. So if the delivery of the child is on the basis of a consideration or compensation or money, kung ibaligya kaya the penalty will be qualified. Also, kung wala man niya, the mere act of delivering is already a crime. Okay, the fact that it is with consideration, the penalty is qualified. Okay? Qualified trespass to dwelling. Half-half ko lang, guys. So, next, we will discuss later on qualified trespass to dwelling and the second part of the Article 9. Okay? So, next time naman, guys. Study for your exams. Take care always. Keep safe from COVID. Okay? Hindi ka mo sa agad lagaw. Okay? Bye-bye.